Number 27, People v. Anthony Debellis.
Good afternoon. May it please the court. Matthew Bova for Mr. Debellis. I would request 2 minutes for rebuttal, please.
Yes.
Counsel's unreasonable failure here at the charge conference to request a defense of voluntary surrender under Penal Law 265-20 effectively led to an admission of guilt and a directed verdict against Mr. Debellis. This is not meaningful representation. Throughout the trial, counsel develops the factual predicate for a statutory voluntary surrender defense under 265-20.
Your position that if a defendant testifies he's going to voluntarily surrender a gun, then the charge is mandatory?
Yes, because under the reasonable view test, where there is some evidence, viewed in the light most favorable to the defense, where there's some evidence, the charge has to be given.
Who decides what's reasonable? Like, is that a gatekeeping function of the court? Can the court decide, you know what, I hear this, I don't think it's reasonable, I'm not giving that charge?
When it comes to questions of credibility and the historical facts, that's a question for the jury where there's evidence on both sides. This court held in people...
What's the evidence on both sides, though, here? Because the entire encounter, I agree with you. If someone gets on the stand and says, I said I was going to turn the gun in, and the cop gets on and says, never said that. Credibility issue. But the entire incident here is taped, video and audio. And time after time he's asked, do you have a gun? And he says, no. How is that consistent with I'm going to turn my gun in to the police?
Because as Mr. Debellis testified, he said it would have made no difference. A reasonable jury could easily find that someone isn't going to volunteer to the police, by the way, officer, I have a firearm, because they may very well be afraid that they're going to be arrested.
They would volunteer that if that's their whole purpose. He's saying, I want to voluntarily surrender my gun to the police. Now, he's stopped by the police, and they say, what's going on? He doesn't say, oh, great, you're here, because I wanted to voluntarily surrender my gun to you.
No, because
And
when
it goes on for a really long time, right? You'd agree with me that, and it's not until the tow truck driver says, you know, I think you guys should look at this bag that he keeps going for, that they find a gun that's loaded and ammunition, that it's known that he has a gun. So, I feel like that's entirely inconsistent. Everything that's captured on tape is entirely inconsistent with a voluntary surrender.
Well, this is exactly the argument that the jury should have had during deliberations.
No, but that is the gatekeeping function. There is a gatekeeping function, which is the equivalent of harmless error almost. No reasonable jury could have found this defense. And here you have the entire encounter taped, and you have him getting back in the car with a loaded weapon concealed there to get his phone charger, all the time saying, I don't have a gun. What possible reasonable view of that evidence supports I was going to turn my gun in?
Well, first of all, just to get back to the standard, the gatekeeping function does not resolve questions of credibility, of what's in someone's mindset.
There's no issue as to what happened here. It's videotaped, it's audio taped, so there's no credibility issue. I said, no, you never said. We know what was said. We know how long it took to say it. We know the entire encounter. And you think it would be per se error for a judge to look at that videotape and say there's no reasonable view of this that supports this defense?
No, there is a contested question of fact, which is what is in Mr. Debellis' state of mind. Mr. Debellis testifies, at that point in time, I was voluntarily surrendering the weapon on my way to the precinct, and that he didn't advertise this to the police officers.
When he denies having a gun, isn't that I'm no longer voluntarily surrendering it at that point? And then we go on and on while he gets back in the car with a loaded weapon concealed, but it's still in his mind. He's like, I'm going to surrender this gun after they tow my car with a concealed weapon in it.
No, because his immunity is already attached under 265-20. And additionally, because the statute says that immunity attaches upon voluntarily surrendering. Additionally, and perhaps...
Sorry, tell me that again. So when did he voluntarily surrender the gun?
The statute doesn't require the successful surrendering.
So when does immunity attach?
When someone
When he says, I don't have a gun?
When someone is voluntarily surrendering. The statute is a person voluntarily surrendering such
When
weapon.
did he try to voluntarily surrender it?
Well, he testifies that he's on the way to do that, and that is a question of credibility and fact for the jury to decide. And additionally, if there were a rule that required someone to make this kind of announcement, which is what this would ultimately be, the only way a person could have immunity would be if they, upon being stopped during the process of surrendering a firearm, say to a police officer, "Mr. Officer, I have a
Why isn't
firearm."
that a good rule for safety? I mean, when you walk up to the precinct, can you just walk through the door and say, "No, I don't have a gun," and then once you get inside, take the gun out and say, "Hey, who do I surrender this to?" Wouldn't it be a good rule that you have to announce once you encounter the police that you're surrendering a gun?
No, it's not a good rule to condition immunity and whether or not someone's going to be sentenced to possibly 15 years in prison if they, simply because whether they're able to have a conversation with a police officer at the scene.
Would you agree that there's some set of imaginable facts where he wouldn't be entitled to the instruction even though he gave the testimony that he gave at trial? You know, for example, he's got detailed instructions in the bag with a gun about how he's going to sell it to a illegal arms dealer. He's got detailed instructions in the bag that show he's going to use it to commit a murder. But he gets to the trial and says, "Oh, actually, I was going to turn it in." Is there some point where you could imagine a set of facts big enough that he would be disentitled to the instruction despite his testimony?
I think no under the reasonable view standard. Under the reasonable view standard, and as this court held in People versus Butts, the standard is simply whether there is evidence which, if credited, justifies the defense.
And what's that evidence here?
Mr.
His testimony?
Mr. Debellis' testimony, and additionally, that's corroborated. It's corroborated by his testimony about his financial motive. He specifically testifies that he's lost his long-standing job, his life was destroyed, and he was desperate.
So you emphasized if credited, not necessarily accepted by the fact finder.
Yes.
It's just if. And that if presupposes that it's going to be submitted to the fact finder to make that decision.
Yes, Judge, that's exactly what this court held in People versus Butts. That's been the long-standing reasonable view standard under Watts, under Padgett. If there's conflicting inferences, if there's conflicting testimony, that goes to the jury. What we really have here is a consciousness of guilt theory. We have a theory that the government can argue to a
We
jury.
got into this before, right? I think last argument. What if this person's on their way to turn the gun in, and they pass a bank on the way, and they're like, "You know what, I'll rob the bank, but I'm going to turn the gun in," and they come out and they testify at trial, bank cameras on. You can't get me for possession of a gun in there because I was intending to turn it in. And I think you said that would be okay, you would have immunity.
If the testimony is that the plan never ended and he was always going to turn it in, then that would be a horrible defense that the jury would absolutely reject.
You get to submit it.
Yes, I mean that's what the reasonable view standard is getting at. It doesn't say you.
Why isn't that, this hypothetical, an example of abandoning your intent? Let's say you've got the intent, and as my colleague says, you see the bank, it looks pretty good. I've decided right now I'm not on my way to turn this in, I'm on my way to rob this bank. Why isn't that now an abandonment of that intent?
Yes, if there's never any further effort to turn it in, yes.
You intend all the time. I'm always intending to turn the gun, and I just stopped to rob the bank on the way doing it.
I think what we're getting at is affirmative abandonment. I think that if there is evidence that the defendant has affirmatively abandoned it for reasons
That is inconsistency, right? It's not abandonment. I never abandoned it. I'm always intending to turn the gun, and I just want to rob the bank on the way I'm going to go do that. That's not abandonment. That's inconsistency. And I'm telling a cop, I don't have a gun, and I'm going back in to get my phone charger while it's hidden under the seat. I don't see as that much different than I'm robbing the bank, right?
No, because the simple argument to the jury in this case that a reasonable jury could accept, understanding what it's like to be pulled over by the police, understanding that they may not accept a person's assertion of a defense, a reasonable jury could absolutely say, sure, if I was in that situation, I wouldn't trust that officer to trust me, so I would simply stay quiet.
But he should trust me to get back in my car with a loaded weapon hidden under the seat. Right? Because I don't have to say anything, I just have my subjective intent, so I can tell him I don't have a gun and get back in my car. None of that is consistent with I'm going to turn my gun in.
No, because the officer doesn't let him into the car knowing there's a weapon there. That's only found half the fact.
He knows, though. Right? Doesn't he get back in the car to get his charger at
Right.
some point? And there's a loaded gun hidden under the seat, which presumably he knows is there, that he's going to return. But he lets the officer let him back into a car where there's a loaded weapon hidden in grabbable area. How is that consistent with I want to turn my gun in?
This is all part and parcel of the same point, which is he must not have the defense because he didn't assert it on spot. It's basically a consciousness of guilt post-arrest silence theory. That kind of consciousness of guilt evidence is speculative, but at best, it's a classic question of fact for the jury.
If I'm understanding you, I'm understanding your point, given the series of questions and your responses. He says one thing at the point he stopped, and then he says another thing that he wants the jury to believe of as to why he said this thing. And your point is two subjective statements about state of mind for the jury to decide versus, I said one thing at this point, and everything else that's objective would go to the fact that my statement is on its face unbelievable. Could you see that those are two different situations?
I mean, I think at best that just goes to a question of harm and a question of prejudice. I mean, whether there's objective evidence that goes against the defendant's testimony at trial as to his state of mind, that's what the jury figures out. I mean,
So there is no incredibility as a matter of law with respect to requesting this kind of defense?
I think you could imagine a situation that is incredible as a matter of law, such that...
Judge Wilson's hypotheticals, the detailed steps of how to commit a murder or something like that.
I don't know. I mean, I don't think that necessarily does it because
That's
that
not
just
good enough.
becomes a really bad argument for the defense, but not necessarily incredible as a matter of law. I mean, it's very similar to prosecution witnesses. When the prosecution calls a witness that gets hammered on cross, the courts never say, and this court would never hold, that that's insufficient as a matter of law because it's so obviously incredible. Credibility questions go to a jury. The fact that a witness testifies for the prosecution that X happened and then testifies that Y happened at trial, that's a credibility question.
No, a
Conflicts in
judge
the...
could decide based on that, I'm not going to give the charge, whatever charge the people are requesting.
Oh, no. Under conflicting testimony on Delamoda, that goes to the jury. The only situation is when it is so incredible as a matter of law that it is impossible. That's not this case. This is a
But what we're describing anyway is not this case, because it's not about the charge, it's about whether the attorney gave meaningful representation, right?
Yes, and what happened here was, it's not meaningful representation. To fight for a client at trial, elicit evidence from the client that he is surrendering the firearm, and then failing to request the only defense instruction, and instead going all in.
How about if, as his client is testifying, the attorney's looking at the jury, and they're rolling their eyes, and they're yawning, and they're clearly not buying it, and he makes a decision, you know what, I'm not going with this defense. I'm going to switch gears, and I'm going with another defense. Is that the single error that we're now going to say was ineffective assistance, so clear-cut, when he made a conscious decision, the litigator made a trial strategy in the moment, observing the jury, observing how his client does on the stand, observing how cross-examination is going, and says, you know what, I don't want this charge.
Well, that would be objectively reasonable on these facts. We know that's not what happened, because what counsel does is he requests the temporary and lawful possession defense on the factual predicate that Mr. Debellis is telling the truth when he testifies that he's surrendering the firearm.
So this would be a harder case for you, I take it you're saying, if there was no temporary possession charge that was requested.
Oh, absolutely. For example, if the evidence indicated that counsel was simply, going all in on the government failed to prove its case beyond reasonable doubt and doesn't request an affirmative defense, that might be a different case. Or where there's two defenses and defense counsel requests one and not the other. But here, defense counsel develops one factual predicate which requires an admission of guilt to a C violent felony, goes all in based on that factual predicate on a baseless temporary and lawful defense that is completely irrational, that the government does not suggest otherwise.
Well,
and
it's hard
instead,
to tag him with that until your client testifies, right? I mean, he was going to get an instruction, and then your client testifies against the advice of counsel, maybe I'm wrong on the record, and then the judge says, based on that, you had this gun too long, and you got on the train with it on your way to turn it in and all. So then he says, you're not getting the instruction. So I take it as at that point you're saying he should have switched, because he had the instruction before that.
so two things on that. First, he can't get any defense instruction, temporary and lawful possession, or voluntary surrender unless Mr. Debellis testifies. And at 1103 through 1106 of the record, the court tells him that. You can't make out a temporary possession defense without someone testifying that the possession was temporary. So Mr. Debellis had to testify in order to get either defense. In any event, though, the critical question is, what does counsel do with the evidence that's before him at the charge conference? Counsel goes all in on temporary and lawful, which has no basis because Mr. Debellis has possessed this firearm unlawfully for a significant period of time, as opposed to the voluntary surrender defense, which is exactly the factual theory that he's trying to get to the jury. By failing to present the only question of fact, the only question of credibility to the jury, and instead going all in on no defense at all, we have a directed verdict. That's not meaningful representation. The right to meaningful representation means that the jury gets to decide whether the defendant's factual defense is truthful, and that didn't happen here. Thank you.
Good afternoon, Your Honors, and may it please the Court. Reva Grace Phillips for the respondent, the Bronx County District Attorney's Office. There was no reasonable view of the evidence that defendant was entitled to either of these defensive charges. I think the trial court very correctly clocked the issue with the common law defense he tried to raise, which was the temporality concern. Defense did, unlike my colleague says, wasn't a baseless claim. Defense was getting a lot of traction with the court with his claim that the temporariness was impacted by the fact that the gun was held in a safe in a home he couldn't go to because he was banned by an order of protection.
What's the standard that applies when considering whether there's a reasonable view? Is it in the light most favorable to the people, to the defendant, to whom?
Your Honor, it is in the light most favorable to the defendant, and even under that standard, defendant fails to have articulated why there was a reasonable view for either of these.
And is that because the people put forth the encounter that he had with the police from beginning to end on the night?
Certainly, I think the video, as Your Honors of all clocks, speaks for itself. I think in addition to the video, we don't just have a pair of statements.
Isn't that, it's not, is it that he must put forth a successful claim in order to get that it's going to be accepted by the jury, or is it that you put it forth and it's for the fact finder to decide?
Your Honor, the judge has a gatekeeping function there where he has to determine whether there's a reasonable view that warrants it going to the jury. The trial court correctly determined
Reasonable view in light most favorable to, but the court is not the fact finder. The jury is, correct?
Correct, Your Honor. Again, though, here there was no reasonable view, as I mentioned, of the temporary and innocent possession. The temporality issue, defense counsel had
Is
obviously...
that because the court decided that it was incredible based upon that tape of the roadside encounter?
No, Your Honor. The court waits until after defendant testifies to finally say, you're not going to get the charges based on his
No,
testimony.
so the court is assessing the credibility of the defendant based upon the evidence and says, no, you don't get that, instead of the jury doing that.
Well, one of the specific things the court points to is the defendant's testimony, and he says specifically, the defendant testifies that he put this gun in the bag, and then the gun is recovered from underneath a floorboard. And the court actually says, I'm jammed on this charge because of his testimony, because he hides the gun. Because as all of your honors...
It's not, and that's not credibility assessment by the court? That it's incredible because I've decided based on the evidence. Instead of letting the jury decide it, I'm going to decide as the gatekeeper, you don't get that charge because the evidence has been presented that when you encountered the police, you never said you were going to turn the gun in, and in fact, you went back and you were trying to get the gun out and hide it from the police.
Well, I think the court cites to a variety of reasons it ultimately denies the charge, but certainly I think it primarily is concerned with temporality, but it also says it's the defendant's testimony that's going to prevent him from getting this charge, and specifically the fact that defendant, while testifying, fails to account for how the gun winds up hidden and why he's lying to the officer repeatedly about the gun.
Is that on the temporary lawful possession charge or on the return of the gun?
So, Your Honor, that was on the common law charge that counsel had requested, but for the exact same reason, the trial court was not going to grant the statutory defense. The trial court, again, makes very clear it's jammed on the charge issue because defendant lies to the officer.
No, I mean the voluntary return charge that he requested didn't get.
Correct, Your Honor. So the requested charge fails, but what I'm pointing out here is that the trial court is also signaling to counsel for the same reasons it's not going to grant 26520. And while we do not have defense counsel on the record saying, Your Honor, there's also 26520 to consider, one, I would point to the fact that the trial court itself references Penal Law 26520 at at A 1390, the trial court says, based on my review of these cases and 26520, I'm denying the charge. I also think that we have to look at what counsel says to the court at one point. Trial counsel is talking to the court, and the court directly asks him, was there a buyback program at the 49th precinct? And counsel says, my client is going to testify to that. And the court says, but do we know? And counsel responds, my client believes that there was a buyback program. So I think the idea that if counsel had just clocked on 26520, he would have made that argument and had success is belied by this record. And I think when we talk about reasonable view here, that has to be, as Judge Singh has pointed out, encapsulated within the fact that this claim is presented to the court under an ineffective assistance of counsel theory. So defendant doesn't just have to prove there was a reasonable view that entitled him to the 26520 statutory defense. He also has to prove the absence of any strategic reason for counsel to have made that decision. And as Judge Singh has pointed out, right, that could be as simple as counsel seeing the jury's face as he's testifying and saying, this doesn't look like they're buying what he's selling. We don't know from the record, unlike what counsel said, we don't know from the record why defense counsel made this decision. And that's exactly why this should have been raised by way of a CPL 440-10 motion, which is what the division found, and I think is in line with this court's consistent and recent rulings that ineffective assistance claims are generally best brought under a 440-10 motion. There are many strategic reasons we can think of why counsel may have made that decision, but the fact that we don't know when we'd be engaging in speculation, I think goes to prove that defendant here can't really prove everything he has to prove to get this court to overturn his conviction. Because in addition to the reasonable view, he also has to prove the lack of strategic reasons, and then he has to talk about prejudice. And this is a jury that heard defense counsel say he had no criminal intent, he was on his way to a buyback. So this is a jury who may not have had the charge from the court, but certainly had before it the concept that defendant did not have the criminal intent requisite.
That's part of the problem, though, I think, is if they have testimony that might provide a defense, but they don't have an instruction from the judge about the defense, it's very hard for them to find for the defendant.
Well, Your Honor, I think that's belied by the fact that they acquitted him of the drug charges. And I think going back to the reasonable view, again, we're not just talking about defendant is in his own car driving to a police precinct. Defendant is without a license driving an unregistered car after having traveled with this gun 50 miles and a bag of Xanax and codeine or oxycodone in addition to
But
about
that all sounds like what goes to the jury, and for the jury to decide. I know he said one thing to the cop. He's gotten on the stand, he's saying something else now, and this is the conduct, and I do or I don't believe him. But a judge doesn't get to do that. That's the fact. The jury, this is a jury trial, is the one that gets to decide that. That's where I'm having difficulty with your argument.
Your Honor, again, so I would argue first that the judge is looking at all of the evidence and says there's no reasonable view given all of these things. You're unlicensed.
Again, but it turns on what he said to the officer and what he says on the stand and his conduct. That to me is about subjective criteria. It goes to the jury.
Okay, so I guess again also, defendant's not saying the court was wrong for not granting the voluntary, temporary and innocent common law defense. That's not what defendant's saying. Defendant is saying my counsel was ineffective for not requesting the statutory defense. So one, again, even if Your Honor's find there was a reasonable view that warranted the charge, that still leaves open the question of whether or not there were strategic reasons not to seek it. And I think defendant fails there as well. Because again, defense counsel's entitled to say, I have multiple defenses I can present, and I'm going to pick the one I think
But what
is
could the
easiest to
reason
reach.
be there to request one but not the other?
Absolutely, Your Honor. So again, as I mentioned, defense counsel, when directly asked by the court, was there a buyback program? Counsel says, my client believes there was.
That's the reason why you think they might not have strategically chosen to request that defense?
Well, I think that we all have to guess at why defense didn't strategically request, and that's why this should be a CPL 440-10. But I think that is some evidence that defendants and defense counsel are talking about the precinct, the buyback. They're having conversations about that. So the idea that defense counsel's not, at all aware of why his client might be headed to a buyback at the 49th, hasn't asked him any follow-up questions about that claim, I think that's belied by that point in the record. I also think you have the court at sentencing saying, I looked into it, there is no buyback program. There was no buyback program
But
at the time.
again, couldn't that have been put to the jury after the people, in response to what the defendant offered, there was no buyback program. Here's what he said one thing to the police here, he said another thing there, and the jury says, incredible, we reject. Isn't that how the process is supposed to work?
So again, I think your question actually underscores, Your Honor, the fact that we need defense counsel to talk about what he was thinking and why he strategically chose the defense he did. Because I think to say the people could have rebutted the buyback program, well, under the voluntary, temporary, and innocent common law, they didn't have to, right?
So the defense he chose or the charge?
So what I'm saying is the defense he actually put forth, the temporary and innocent possession, we didn't have to rebut the precinct had a buyback program because that wasn't what that defense would turn on.
You're saying he
265-20 would.
changed things midstream.
No, Your Honor, I'm trying to articulate that if he had sought the 265-20, the statutory defense that defendant now says was the appropriate one that would have won the day for him, if he'd sought that, the people would have rebutted it by presenting evidence.
Just to be clear, you're saying the defense is unavailable if the buyback program is not in effect during the period of time that the individual says that they're trying to return the gun, even if they authentically believed that the buyback program was in effect? I just want to understand your point.
So I guess I would respond with 2 points. So one, I think this goes again to the gatekeeping function of the judge. Is there a reasonable view of the
No,
evidence?
that was a yes or no. That was a yes or no.
I'm sorry, can Your Honor repeat the question then?
Requires a yes or no response. You can expand on it, but I need the yes or no up front.
So as to 265-20, no. I don't think a defendant would be entitled to the charge where there is no buyback program.
So even if the defendant mistakenly thought that there was, and honestly thought that, or maybe had gotten some literature that had the wrong date on it, and believed that there was a buyback program, it wouldn't matter if there in fact wasn't a buyback program. That's the end of it.
I think in light of Your Honor's hypothetical, I would change my answer. Yes, I think that there could be, you could be entitled to that charge where the defendant articulates some mistaken belief in the fact that there was a buyback. Here we have the opposite. We have a defendant.
That was the question.
Yes, my apologies, Your Honor. I would agree that there are factual scenarios where a defendant could be incorrect about a
But then the
buyback.
existence of the buyback program seems as if it goes to credibility of the witness, really. It's not an ironclad bar to the defense.
Well, again, Your Honor, I think here we do have defendant testifying that he looks it up and that there is a buyback program. But the reason that I raised the lack of buyback isn't, again, to attack defendant's credibility. I think that's the reasonable view question. I think this goes to the 44010 question, why this should be raised by way of a motion. Because we don't know why defense doesn't seek the 265-20, but we can easily imagine that he contacted the precinct, he asked his client.
Let me just, fair enough. So let's say we agree with you, brings a 44010, attorney, there's a hearing, the attorney gets on the stand and says, I don't remember why I did that. I have no recollection. I assume your position would be that then the motion fails because they haven't met their burden.
Well, I think a 44010 would be useful for a variety of things. So one, I think if counsel testifies, I was unaware, then we look to...
But in my hypothetical, the lawyer generally said, I don't remember why I did that. I really don't.
So I think if counsel can't articulate a strategic reason, then we move on to assessing the prejudice. And again, I think that at a 44010, the people would be entitled to introduce rebuttal evidence as to the 265-20 claim. And I think here where we have a jury who, again, gets a flavor of this defense, whether or not they get the charge from the judge, and still convicts defendant, but doesn't convict him of the drugs. I think it's a hard press to believe that this is a jury that was going to acquit him but for the lack of getting the formal charge from the judge on 265-20.
Well, that's fair. His argument is bad. The question is it's so bad that he doesn't get the instruction.
I think the answer is yes, Your Honor. And again, I think that we have more than just defendant's statement and Officer Allen's statement here. We have a wealth of evidence that proves why there was no reasonable view that this was temporary and innocent possession or that this would have been voluntary surrender under 265-20. I'll briefly turn to the conflict point. I think defense counsel's very brief remark at sentencing cannot constitute conflict warranting the necessity of replacing counsel. Counsel is merely defending his performance. That's something this court has approved of before. But I also think if you look at the context in which counsel's statement is made, he's really trying to protect the defendant's rights by alerting the court to why it should not dismiss the motion outright on technical and procedural bars. He's trying to ask the court to please give this actually some more thought than just saying, well, he didn't file it right, so I don't have to look at it at all. And I also think the fact that the sentencing court specifically says, well, counsel, it doesn't really matter to me if you adopt the motion or not, and it doesn't really matter to me what you do. I'm going to do the same.
What was the point of saying that the counsel believed they were very effective?
Absolutely, Your Honor. So counsel is saying, first he says the judge, here's his pieces of paper. And the court goes into this whole thing about, I don't need to look at this. You're holding a piece of paper. Counsel says, but I think I might need to be relieved. And the court says, I have no basis to relieve you. I have no motion before me. And that's when counsel's saying, yes, but he's saying I'm ineffective. And, Your Honor, I'm not going to argue that because I think I was effective. And then the court gets a copy of it. And then the court readily sees.
Why isn't that undermining the motion?
Because it's not discussing the merits of the motion.
No basis for this motion.
Well, he's not saying there's no basis for this motion. I think that would be Mitchell.
I thought you said what he says to the judge is, he's arguing I'm not effective, and I think I was very effective, so I can't support the motion.
I believe exactly what he says is,
Yeah.
Your Honor, he's alleging things I'm not going to argue on his behalf. He's alleging I'm ineffective. I'm not going to argue that. I think I was very effective.
Well, I'm saying, isn't that telling the judge there's no legal basis for the motion?
I wouldn't say that, Your Honor. I think in Mitchell, we have a much more clear case of that, where the attorney actually says outright there's no merit to this motion, and then the court replaces that, substitutes counsel. Here, he's using that statement to really flag for the court why they should look a little bit more at this, and then the court, seeing the utter paucity of facts provided by defendant,
And
rightly
so
rejects
are
it.
you arguing, he could have even been cueing the court that if you want to relieve me, to get counsel to explore the issue, but it's something for the court to at least consider because of the flippant way he did respond.
Absolutely, Your Honor. I think he's 100% trying to make sure that the court is paying as much attention to his client's rights as it can.
You're essentially, you're treating as if he said, there's a conflict. I would have a conflict.
Certainly, Your Honor, and then the court looks at the motion and says, well, we don't have to get there because I think this is such a frivolous motion that I'm going to dismiss it out of hand. Thank you for your time, Your Honors, and we ask that you affirm.
So just as to the court's decision, the argument that a citation to 26520 at A1390 is somehow the court considering the voluntary statutory defense that's the first time the government has made that argument here today. The line, though, that the court says is this defendant's temporary unlawful possession defense applies because as a matter of policy, the court's describing the law, saying temporary unlawful possession applies because as a matter of policy, the conduct is not being criminal.
Was there confusion perhaps at the trial level that it's all one defense instead of two separate ones?
No, there was no confusion at all because the defense counsel never told the court that it should consider the statutory defense under 26520, and at A1390 through A1395, the court expressly denies the instruction because he says your possession is not temporary. As the court puts it, you cannot ignore court orders to surrender weapons. You cannot have unlawful possession, then all of a sudden decide that you're going to drive several hours. However, the voluntary surrender defense does not have a temporal requirement. It does not require that the possession be temporary. The big problem here, the discussion here of jury nullification, and whether or not it would be reasonable for counsel to do what he did, is that he has a factual predicate for an actual defense, but he only uses that factual predicate in support of a baseless defense and a jury nullification defense.
So why don't we need a 440?
We don't need a 440 because we know that counsel's factual theory, his goal, his strategy, is to get the question before the jury of whether Mr. Debellis is testifying truthfully when he says that he is going to surrender this firearm to the buyback program. That question of fact, however, is used by counsel to support a baseless defense as opposed to the buyback defense. This is exactly, it's very similar.
There is legitimacy to him pursuing a jury nullification, or there's not?
It's unreasonable performance and deficient performance and violates effective assistance to pursue jury nullification at the expense of a real defense, especially where the real defense...
That's where I'm having the trouble, because you're saying that here, years later, looking at paper, and counsel made a decision as a litigant in that courtroom saying, I'm not going to go there. I think jury nullification for us right now at this juncture is better. And we now have to say that that one decision is basically ineffective assistance of this attorney. And I have a real problem with that.
Well, it's because of the uniqueness of this record. No reasonable attorney pursues jury nullification as the only defense based on a factual theory, which is what counsel did, factual theory of voluntary surrender, instead of pursuing the real defense and then also making the same argument.
So are you saying basically jury nullification should have only been pursued if that statutory defense did not in fact exist?
Absolutely, yes. But once the court shuts down the temporary and lawful possession defense that is based on the factual predicate of buyback, any reasonable lawyer requests the applicable legal defense and does not go all in on a mercy plea that, as the judge reminds the jury over and over again, is not the law. You are not allowed to acquit someone because you feel bad for him that he was down on his luck and was surrendering the firearm. The jury should have been able to decide, however, whether crediting that testimony justified the factual and legal defense of voluntary surrender.
Your red light is on. Can you maybe take 30 seconds on the conflict of interest issue?
Counsel says I was very effective. Under Washington and Mitchell, that is taking a position adverse to the merits of the motion. Counsel's option is very simple. He simply says nothing, or as he does here, he asks to be relieved. The problem is that he asks to be relieved, and then he undermines the merits of the motion. This is not a difficult thing for counsel to do. It's exactly what this court has already
Is there any
held.
law on the buyback requirement that there has to be a program, a good faith belief that there is a program? Is there any law on that out there?
Well, there's no question that there is a buyback program. I mean, people versus...
An active buyback program where he's going. And I think you were asked this, or someone was asked it before.
So
Is that an element of this?
the only,
defense?
just to be clear though, the only theory, I think what the government means when they say there was no buyback program, they just mean whether you can get money. But it is always the case for the buyback program that wherever you go, you can surrender it. It's just a question of whether you're going to also get the money.
Well, that was the way he testified, was it not, that he was doing this to get money?
Yes, but either way, under the terms and conditions of the buyback program, if he gets the precinct wrong, or he goes to the 49th precinct as opposed to the 48th precinct, he could still surrender it lawfully under the terms and conditions of the program. So whether or not he gets the monetary reward fact right, it really doesn't matter.
There's always an ability to turn a gun in under the statute.
Yes, and that is good policy, and that's why we have this statute, to incentivize people to surrender firearms so they don't fear criminal prosecution. So that question of did it exist or did not really is not germane to the case.
Thank you.
Thank you.